is you've got all these external voices. Let me ask you this question. How many owners have received a call or a postcard or some type of solicitation that somebody's interested in buying your business? Yeah, for those of you who can't see, almost every owner in the room. And so you're getting lots of attention and interaction at the strategic and execution. You're getting lots of people giving you messages about this thing out here that's not at all important to you. They're giving you advice in a way that doesn't resonate with your natural wiring or your style. You're hearing things like, you need to mitigate your risk. You need to diversify your asset. All of your assets are tied up in your business. You need to diversify it. Well, how many of you think about your business as an asset that needs to be diversified? But you're getting all of these, and that's the disconnect. So when we talk with advisors, Patrick alluded to, it's why the cat doesn't bark. When we talk with advisors, they look at us like, what do you mean they don't think it's an asset that doesn't need to be diversified? All their wealth is in this one place. And so we try to help them understand your wiring just a little bit. But this is how they experience you. Because their job is to protect you. Their job is to make sure you have wills and trusts and buy-sell agreements and all these technical instruments. And the research tells us that 67% of owners who have an advisor, that's a wealth manager, a CPA, an attorney, some type of technical advisor, those owners, 67% of them say, yeah, I know I should plan. I know I should plan for this thing called succession or exit or transition. That means the advisor's done a good job of helping you know you should plan, but then those 67% say they don't. They just don't plan. It's not a risk they need to mitigate. And they also think they're covered. And this is a little bit of where advisors miss the mark. Because they give you a piece. And so you think you're covered, you think you have a holistic plan. And this really hit home for Andrew and I in particular when we worked with a client whose dad, we'll call our client Jim, and his dad had built a really pretty impressive industrial distribution company in Southern California through a pretty difficult time. He'd run it for over 30 years, and he died suddenly. Now, Jim was in his late 20s. Younger sister was about 22. Jim had worked in the business his whole life. He grew up sweeping the warehouse floor to lead the sales team for his father's firm. And when Dad died, Jim and his sister became 50-50 owners. And they didn't get to run the business right away. It turns out the trustees got to run it for 3 years. And it turns out that Jim's dad thought he had done the kids a good service because he had a trust, he had insurance, he had a will, and he had a succession plan. So he thought he was completely covered. But his family law and business attorney drew up the legal documents, and his company's CFO drafted the succession plan, and guess what? Those three were the trustees. And for 3 years, they ran this business into the ground while Jim and his sister were fighting in court to get control. The only reason they got control is because they agreed to sign an indemnification agreement and let the trustees off the hook. And when we got called in, it was 2 days before he got control, and we found out the business was 90 days away from the bank calling all the notes and shutting them down.